I just want to start by acknowledging the traditional owners of the land that I'm on, hosting this webinar on today, the land of the Wurundjeri people of the Kulin Nations, and also acknowledge the traditional owners of the various lands that you are working on, and Aboriginal and Torres Strait Island people participating today. I pay my respects to the elders past, present, and emerging, and the elders from other communities who may be here today. So good evening. And welcome to today's webinar on the Draft Electricity Transmission Company Statement of Expectations. My name is John Hamill and I'm the CEO of the Essential Services Commission. For those of you who aren't familiar with the Essential Services Commission, we are the state's independent economic regulator, and we regulate things like energy, water pricing, local government rate capping, which you may be familiar with in some areas of transport, like the Port of Melbourne, taxi pricing, and a number of other things. We also administer the Victoria Energy Upgrades Energy Efficiency Program. The work today falls under our role as the energy regulator, and we license energy companies within Victoria. Before we begin the proceedings properly, I just wanted to thank you for joining the webinar and just remind you of a few of those protocols that we've all got used to over the last couple of years. In this webinar, please let us know if you've got a question or a comment. And if you do want to do that, simply send a message to the host and the panelists in the chat stating you have one. This will ensure everyone has a chance to have their say. You can also ask your question in the Q&A function at the bottom of your screen, and we'll see the question and we'll ask you if you'd like to speak directly to the group or have me read it out, or if you have me read it out. Also, if you could be aware that this webinar is being recorded, so we will host it online so people who are not able to attend can review it as well. I also want to take the moment to recognise that this issue around land access has obviously raised very strong feelings in the community about the issues that we've been talking about. But I'd really appreciate in this context that we could remain respectful throughout the discussion and the way we deal with it, but also, of course, acknowledge those feelings and the concerns that people have, which is actually, of course, why we're here. I'd also like to introduce our panelists for this evening and speakers. They will be here to answer questions and also do part of the presentation. So for those, when I speak out your name, you could wave your hand, that would be great. So we have with us Sarah Shepherd, who's the Executive Director of Energy at the Commission. We've got Aaron Ewan, who's our Senior Regulatory Manager for Analysis and Reform. And finally, Meryn Wilson, who's the Manager of the Reform team and is leading the project. So welcome to all of you. We've also got Alex and Sukhmani, who've been working behind the scenes to make all this happen. So now on to today's purpose, and to have a bit of a discussion about the Commission's draft Electricity Transmission Company's Statement of Expectations relating to land access. This is our first formal piece of engagement on the work, but it won't be our last. So our aim tonight is to provide some brief information about our work on the Statement of Expectations, our timelines, and what we've done so far. But really, primarily, we want to hear from you this evening. We really want to spend our time listening to your thoughts and concerns to make sure that the Statement of Expectations captures the things that are really important to you in the context of managing your land and dealing with issues associated with transmission access. Land access for transmission companies is obviously becoming an increasingly important issue as transmission companies build energy infrastructure to meet Victorians' growing renewable energy needs. So around 2 weeks ago, we released the Draft Electricity Transmission Company Statement of Expectations. And this is a new area of work for us, as Victoria currently has no regulatory instrument that sets out how electricity transmission companies should access land under Section 93 of the Electricity Industry Act. In practice, land access can occur through a voluntary agreement between a transmission company and the landholder. If a voluntary agreement is unable to be reached, transmission companies utilise their powers under Section 93 of the Act. The Statement of Expectations that we've developed and draft is designed as an interim measure to address this gap and we expect to follow it soon by an enforceable access code. However, we did want to ensure that companies undertaking this work consider the needs of local communities as well. We started with a statement of expectations in this way so that we can get it moving quickly, because access codes take a bit longer to enforce, to create, really because they would apply to all transmission companies into the future and would require a full consultation across the whole of Victoria as well. So the timelines have been short, but the draft statement of expectations has been developed after listening to concerns that we've heard directly from landholders and those working with them. We have taken into account some early feedback about the nature of the concerns when creating the principles in the statement. It also draws on various land protocols used in other jurisdictions in the Victorian Farmers Federation land access policy. So landowner and community interests have been front of mind as we've developed this draft statement, and we want to ensure that this statement encourages a collaborative approach to land access. I also want to take a moment to thank the Australian Energy Infrastructure Commissioner, Andrew Dyer, who's also provided useful early insights for us when developing this based on his work that he's been doing on the ground. So that's sort of my introductory statement for this evening. And I'm now going to hand over to Sarah Shepherd, who's the Executive Director of Energy, who will give you a bit more of an overview of the work. And after that, we'll get into the discussion and questions. So I hope you do find this webinar useful and choose to provide us with feedback on the draft statement. So over to you, Sarah.
Many thanks, John, and thank you everyone for being here and giving up your time tonight to come to this session. So I will make this short because John has said we do want to focus on hearing your thoughts tonight. So just first, a bit of context. The reason we're running this process is because of concerns we have heard about the way land has been accessed in Victoria for early works for transmission upgrades. In particular, the specific project that, of course, has raised concerns is AusNet's proposed Western Vic upgrade. So it's the concerns that have been raised in this particular project that's led to the development of the draft statement of expectations that we're talking about tonight. However, we've decided that this draft statement should contain broad principles related to land access that can apply to any upcoming transmission project, not just the Western Victorian one. So hypothetically, if we as the Essential Services Commission were to license Mariners Link and they were to start early works, this statement that we're discussing tonight would also apply to them. So that is why, as you read the statement, you'll see the principles are not specific to the Western Vic project. So as John mentioned, we've developed this draft statement of expectations as an interim measure, and we'll follow it up with an enforceable access code, and we'll commence work on this as soon as this statement has been finalised. So I'd like to briefly tell you about the concerns that we have heard so far about how land access has occurred in the context specifically of the Western Vic project. And the first thing that I would say is that we have heard some distressing stories about the interactions with AusNet about access to land. We know that sometimes people have felt intimidated, unsafe, and powerless. We know that there have been times when the police have been involved. We've listened to stories from landowners who felt offended by the way that AusNet spoke to them about their land, and from landowners who felt that AusNet did not understand the depth of their connection to their land and its intergenerational significance to their family. In addition to this, we've heard concerns about a lack of flexibility about when land is accessed. We've heard about the lack of a clear and effective complaint or dispute handling process. We've heard circumstances of those accessing land not being adequately trained to do so. And we've heard about land access not being a collaborative process. So we've used what we've heard as a starting point for this draft statement. So the draft statement that I'll just go into in a bit more detail now, it's available online, and Alex in my team has emailed a copy out to all attendees prior to this evening's webinar. And I think we're popping a link in the chat now in case you haven't been able to see it. And also, if there are people who are having difficulties accessing an online version, please do let us know and we'll mail you out a hard copy. So I'd like to take you through an overview of what is in this statement of expectations and what we hope it will address. And Alex, could you please get these principles up on the screen? Thank you. There are 22 principles in the draft statement, and we expect that these principles would be applied as minimum requirements where an electricity transmission company accesses land. And the principles come under 4 headings. So the first is approach to communication and engagement. And in this section, we set out the principles that transmission companies should adopt when planning a project that will involve land access. And to pick an example, one of the principles is an electricity transmission company will provide affected landowners with an accessible point of contact in the company. They will be available to respond to questions and address issues promptly during all stages of a transmission project. So what this means in practice is that we would expect if a transmission company is scheduled for a visit on a Monday, if something arises over the weekend prior, that means there's going to be a difficulty with that access, that the landowner would have a contact available to speak to over the weekend about that Monday visit. The second heading is around process of communication and engagement. And this is about the principles that transmission companies should adopt before, during, and after accessing land. An example of one of these principles is an electricity transmission company will ensure that anyone contacting landowners regarding land access, whether by phone or in writing, or on behalf of the electricity transmission company, will clearly identify themselves and who they work for and specify the purpose of the visit. And this principle is designed to ensure that landowners have transparency about who is contacting them to access their land and why that access is required. The third heading is managing the impacts of access. And in this section, we set out the principles transmission companies should adopt to minimise any damage to land, infrastructure, plants, livestock, and of course, people when access occurs. And to take one example, which is fairly self-explanatory, an electricity transmission company will take all reasonable actions to ensure that in accessing land, it does not spread weeds, pests, or pathogens. They will consult with landowners to understand property-specific needs and provide details of environmental and biosecurity policies and plans on request. The final heading is managing disputes effectively and fairly. And this principle clearly sets out that there must be two processes. First, a clear internal complaints handling process, and secondly, a robust external or third-party dispute resolution process. Thanks, Alex. You can probably take that slide down now. So our draft principles have been designed to ensure that land access for transmission projects is done in a fair and transparent way, which focuses on collaboration and takes into account the rights and views of the landowner. So as John said, tonight we want to hear from you about the challenges you've faced or might face during land access for these projects and what you think of our draft statement of expectations. A little bit about the time frame. We have set up a web page on a platform called Engage Victoria. We set that up on the 10th of March to start seeking initial views. Then 2 weeks ago, we released the draft statement of expectation that we're talking about tonight and opened formal consultation on the draft. So formal submissions are due by the 12th of April. That's a submission in writing, essentially. But of course, we're taking into account all the feedback that we're receiving in all of these forums. And we are going to work towards a final statement of expectations to be in place by the end of April. I do know it is a tight time frame, but as John mentioned, we will conduct another more extensive consultation process as part of developing an access code in the near future. That's all from me, and I'll hand over to John to run our question session. Thanks.
Yeah, thanks, Sarah. So that's sort of a bit of an outline from Sarah of the approach and the statement of expectations. So now I guess we'd like to really open it up to any thoughts or questions that you might have. If we can't answer a question immediately, then we can take things on notice and provide an answer in the future, or we'll take it onto account when we're doing further work and further developing the statement of expectations. Of course, it isn't by any means a final, and we're absolutely open to ideas for new input into it and how we might change it to make it better or stronger or more effective or more connected to what reflects you think are the important things. So, do we have any questions or comments? So if you do want to make a question, just you can put a comment in the chat if you want, or if you wanted to make a statement or anything like that. We're really interested actually in whether you think the categories that we've put in here, that the areas and principles actually reflect the kinds of behaviours that you would expect or need, and what's most important in terms of engagement between yourselves and the transmission company. Sorry, but I think we've got something from Vicky. In the statement, part 21, implement effective complaint handling, and part 22, offer dispute resolution. ESB is not in the mix at all. Responsibility transfers to whatever complaints procedure the electricity company might develop or offers recourse complaint to the Energy and Water Ombudsman. So I think just in terms of your comment, Vicky, if I might explain, I think the role that this document plays in relation to EWOV, and we did talk to EWOV in the development of this document, a statement of expectations, to help see from their perspective if they would find it useful as a mechanism for resolving complaints to EWOV. So the way that this works under the statement of expectations is that people can in the first instance, there'd be an expectation that they've raised a concern with the transmission company. So for argument's sake, wasn't it? If they're not comfortable with how that's being resolved, then you can go to EWOV. Now, the way that EWOV would use this statement of expectations would be as a guide to assist with the resolution of the dispute. And so we've talked with EWOV as to whether they think this document would be a useful mechanism to help them, and they've indicated that it would be quite a useful mechanism for them in terms of helping resolve the dispute with EWOV. So that's the way that it works. This document will work in relation to EWOV. The other part that we're thinking about and working through is suggesting that the transmission company should be reporting against some key measures and performance measures against us as well, so that we get some transparency about how they're going against the statement of expectations. So that would increase transparency with everybody around what's happening on the ground. So it's probably a couple of mechanisms for accountability built into it. And finally, once we develop the code, then it will become an enforceable regulatory obligation. So hopefully that gives you a bit of context, Vicky, unless you wanted to talk to your point a little bit more.
Just while Vicky's maybe coming on, I might just mention that we are keen to hear if people have tried to raise complaints with EWOV and that hasn't resolved your complaint. We want to hear that, because we're consulting on whether this is the right dispute resolution process. So I'm not sure, Vicky, because you said that's not working at the moment.
If you want to talk, you feel free to turn on your sound, Vicky. I think you might be on mute.
Sorry, can you hear me?
Yep, I can hear you now.
I think it was because I'm just starting to ask another question about how you get their accountability. So I was going to be asking about section 1.5 reporting outcomes, and you say that the Commission may request an electricity company to report outcomes achieved. So I think much of what you said in the principles and the examples are make a lot of sense. They're all common sense. Sorry, I just need to. Sorry, there's suddenly background noise. Makes a lot of sense, but I think that the concern is, how do you monitor, how do you oversee, how do you ensure at a pretty rapid pace that the proponent, obviously in this case AusNet for all of us listening, will respond quickly, will actually meet your expectations as much as they meet our expectations. So I know you can't sort of answer that, directly, but I think that's a concern that the communities would not like to see, that things would fall into limbo, and that issues would devolve to somebody else, because certainly the proponent at the moment, AusNet, even though they're getting complaints, are doing nothing about it. And then the commissioner, EWOL, is sort of saying in a lot of instances that it's not their purview either. To deal with the complaints. So we're literally rocking a hard place. We've got nowhere to go and no accountability.
Yeah, look, I think it's an interesting balance to be had here, because I think some of the concerns we heard that were complaints mechanisms that are in place at the moment were often straight back to the team that was doing the work, rather than a separate person and AusNet. And I think in terms of how do you get quick action is a really interesting question in this context. And the quickest action would be for AusNet to remedy whatever the issue was, I would have thought. And the second quickest is probably a dispute resolution mechanism. So that was sort of behind our thinking, and accountability by way of enforcement via a regulator tends to, by its nature, take a little bit longer to do. So I know that that's kind of our thinking, but if you've got any other ideas about how to have speedy resolution of issues, we'd really appreciate hearing about that.
Thank you. I suppose it goes back to what would ESC be requiring of AusNet to set up a dispute resolution framework. You know, I suppose it's, as I said, the statement of expectations, a lot of it's very common sense, but it's the enacting of it, and it's the meeting you halfway that the proponent may or may not do. And it's this proponent, for example, this has been 1.5 years of them not acting appropriately. So we're all gobsmacked that any organisation can, for 1.5 years, not act appropriately. So I think that's where we'd be wanting to see that there was something put in place where they have to act appropriately.
I think thanks for that, Vicky. I really appreciate those comments, and I think we'll do some further thinking about that, but certainly transparency is the first point, and we can think a little bit more about some other options as well, maybe around how do you give assurance to the community that these things are happening on the ground. And there are some tools we have in a toolkit around audit as well, which could look at whether the systems are really doing what they said they'll do. So we'll have a bit of a think about that. We've got some other questions, I think, from Barb. What consequences will be there for a transmission company for inappropriately accessing private landowners' property that is not in an easement by use of intimidation tactics? Sarah, do you want to have a go at answering that question?
Yes. So, Barb, did you want to elaborate on that at all? Might just have to go off mute. Sorry, it's a bit complicated process. Okay, so yeah, maybe not, but look, I think so there's a couple of different ways to look at this one. So there's, I suppose, if we're talking about use of intimidating tactics, and that's one of the things we've heard and are very concerned about. The statement of expectations in the near term is something that the regulator expects TNSBs to comply with. So at this stage, the consequences are that the regulation would be much stronger when we come to making that regulation. So what we're trying to do is do an interim step that really goes from not having any regulation in place to having something where we've got transparency and we've got some accountability there. And then we'll be very closely monitoring the conduct during this time. And if we're not satisfied with the conduct that's happening, the regulation is likely going to be very rigorous, and consequences of not complying with the code are very serious. That could lead to revocation of licence ultimately, and where the body that licenses the transmission companies to operate in Victoria. So ultimately, the consequences could be very severe. So, Barb, I've seen you've gone off mute. I'm not sure if you wanted to elaborate.
Maybe
can you hear me now?
Yes.
Sorry, I'm at my daughter's place with the grandchildren, and they're running around laughing in the background. So So I'm quickly going on this. So I have brought up an issue. I did bring it up, or it was brought up with Andrew Dyer, and I'm waiting for AusNet to reply. So this isn't, we are affected landowners, but this is on behalf of another landowner. And so I will be sending through the 40-minute video that the landowner took of the way AusNet had treated him. The police were called, and so I've made an official complaint with AusNet, and it's probably probably nearly 10 days, and they haven't responded yet. But another landholder, she had sent a complaint through, and really she was just given a reply that acceptable protocol had been used, and both of these landowners weren't refusing access to AusNet. They did have like a legal representative, but AusNet were in a hurry, I guess, to get it done. And so it's just been sort of going on for so long. Just wondered, what consequences can there be, and who's going to make them accountable?
Thanks, Barb. Well, we are here to say we are going to make TNSPs accountable for the way they access land. And it is, this is really helpful to hear your stories, and that it's been going on for such a long time. So I know it must feel a bit like, is anyone ever going to be held to account? But that is why we're here, and that's a very helpful story to hear. Thanks.
Yeah, so the landowner, he did manage to video. He was on his own, and he did manage to record the whole episode, and his neighbours as well. So he'd be happy for me to share that with you, and you could make a judgment yourselves. But the other issue is, if a landowner refuses access, then what sort of procedures are going to be in place?
Yeah, I think we need to, and this is such a difficult issue. We're here to make the process work as collaboratively as possible. But there is a limit, because the law does give AusNet this power, that if we're trying to make the process as best it can be, recognising that transmission companies are given this power under the law. So what we're going to be trying to do is understand whether there is any way that landowners who, for many good reasons, don't want any form of access, on what circumstances they might consider access is reasonable.
I wonder, a couple of additional thoughts, and this relates to Darren's next question about what's the purpose if it's not an enforceable access code. And it comes to this question of accountability. And one thing I would observe about why we might want to get this in place quite quickly is it also provides landowners with something that they can point to in terms of what the regulator expects around land access, in terms of things like timeframes and so on. And in the context of how quickly they're responding to complaints, I think that's a really interesting and important observation. And we can certainly think about how we might build in some reporting and accountability around the timeliness of responding to complaints. So if you wanted to suggest something about that, I think that would be something we could definitely think about in terms of what does a good complaint resolution mechanism look like. It might include characteristics like the complaint goes to someone different than the project team, and it might include some expectations that a response will come back to the complainant within a certain kind of time frame that's reasonable, so that you're not left hanging around a response, and therefore if that's still unsatisfactory, you can proceed to EWOG in a quicker frame. So that's that's certainly something that would be interesting to hear. And I think we could also think about in this context of some reporting and transparency about how those complaints are being dealt with by us. How many of them have they received, how many have they acted on, how many, and within which timeframe, so we can begin to see a bit of really transparency around it, which forms the basis of accountability in the long run as well. So that's just a couple of thoughts about those questions, which I hope you can may be useful to reflect on.
All right, thank you. You can unmute me now in case the girls make a noise again. I mean,
that's all right. We've been used to over the last 2 years of having children and pets and all sorts of things turn up in our Zoom meeting. It's been one of the great things of online work.
Yeah, go, John. If I can, it's Darren Edwards here.
Hi, Darren.
How you going? Look, if I can just respond, I think accountability is probably one of the key words of this entire issue. And I mean, as Sarah mentioned before, AusNet have the powers under Section 93, but they're completely abusing those powers in the view of Energy Grid Alliance and in the view of all the communities. And there is no accountability. I mean, when they have this power and they know they have this power, they're not accountable to anybody. They're not accountable to the government. They're not accountable to you guys. Not accountable to anyone. And I think that really needs to change. I mean, we can't expect for this project or the transition to a renewable future where there's going to be 5,000 k's of transmission lines rolled out across Victoria, that AusNet are just able to do anything they want, anything they choose in terms of consulting with community in an acceptable fashion without any form of accountability. I mean, it's if this was any other business, the project would be canned by now because of their behaviour.
Yeah, I completely agree, Darren, about the importance of accountability. Give you a bit of a sense of our thinking. We're happy to take feedback about faster ways of achieving this. One of the pieces of work that I've been recently working on is around new connections and greenfield development. And there was a lot of disagreement between distributors, electricity distributors in this context, and building developers in new areas in particular. And the thing we started out with to try and fix that were essentially business-to-business relationships, which seemed a bit dysfunctional, was to build transparency around performance and have an ongoing discussion between people about what performance expectations were before codifying it. And what we found really valuable was a lot of misunderstanding and miscommunication was behind this, and the need really on the distribution companies to invest in the relevant infrastructure to make it work. So some of our thinking in this space is connected to that idea that we need to really begin by increasing transparency in terms of the relationship, and behind that will come accountability. But if you've got, it's an interesting question. It's something that we thought was a good way to do it and a quick way to begin the process of improving relationships between transmission companies and landowners, and also make sure that the regulatory settings aren't mishit and cause unintended consequences. But that's kind of our thinking, I guess. The other comment I think Mirren's just suggested to me is the other area of accountability is under the legislation. There is, of course, accountability for any damage caused as well. So this is supplementary to actual obligations that the transmission company has to repair any actual physical damage. Now, that's sort of at the extreme end of things in this kind of context, but it is something that's there in the regulatory framework.
Okay, thank you.
How are we going for? Got any other questions there? Just having a quick check in. So if there's a comment from Nate, landholders should not be subject to the statement of expectations when they've only just been considered a stakeholder in this project to be able to initiate Section 93 it should be a requirement to have landowners as stakeholders from the commencement of the planning of a particular project, not halfway through. And transmission companies are only out to tick the box for an EES. I think that's a really interesting comment in terms of what should happen around getting that kind of social license for engagement on a particular project. It's our statement of expectations doesn't quite get to the consultation obligations around a particular project. But Nate, if you wanted to maybe expand a bit more on your comments, really interested hearing them.
Yeah, I find it interesting that your landowners are inflicted upon a Section 93 when at the commencement or prior to that, they're not included as stakeholders in the whole business or in the whole project. Now, your local landowners are the ones that actually have on the ground knowledge of the landscape, the economic impost that these transmission lines can cause through agriculture, through tourism, through your communities. Yet they're the last ones to be consulted, and you're doing an access arrangement for an EES project or an EES process when the alignment or the method of how they're proposing to put this transmission network through could be flawed from the start. So you're not fighting in that sense, but you're arguing a point, and this is why there's so much angst in the community for no access, because there's a whole community going, this is not correct and this is not right, and why would we be giving access when blind Freddie can see that that this alignment isn't correct. So when you're halfway through a process and it's now just the only avenue out is an EES process, why would you be giving access to let a proponent come in to tick their boxes to do an EES when you haven't been consulted through the whole process? Now, you'd all be aware that AusNet's consultation has been less than deplorable. In this whole process and community feedback too, yet we're still continuing the same alignment as what was set out on the original mail out more than 18 months ago. So there's questions over the whole process, and it shouldn't start here at access. It should start way before that when you're planning a process either with the AEMO or the new legislation placed in with the hands of the Victorian government.
Yeah, thanks, Nate. And there's no doubt that that's an issue in the broader context of the planning for specific projects and at a number of different stages when they're being conceived of. And I really appreciate those comments, and we can certainly acknowledge them. We're doing what we can within a very, I guess, specific time frame with specific context around this whole land access issue, but we can certainly that is framed by that particular legislation around Section 93, but we can certainly pass on those views back to various stakeholders that we have around how those individual projects are being planned. It's probably not a lot of it doesn't give you a lot right at this stage, but I can certainly
so the community's reaction to this at the present stage, it's a stopgap measure to actually instigate the speed of this process through here without actually having proper legislation in play. So it's a stopgap measure to speed this process up without doing the due diligence that was meant to be done well before this period of time. So there's going to be a lot of angst whether you get this through or not as a statement, and you're still going to run into the same access issues.
Yeah, look, I think we hear those concerns. I would say this is not intended to speed up any process. This is intended to ensure a more consultative and collaborative approach to AusNet's use of Section 93, but definitely hear your concerns.
So I think we've got a question from Russell, or that the electricity company should have to supply the landowner with a map of their property showing in detail where and what type of investigations they want to carry out on the property. Did you want to expand on that a little bit more, Russell? It's sort of an interesting comment rather than a question, and certainly something we could reflect on in terms of how we might fit it in to the statement of expectations or the subsequent code.
Yeah, hello, can you hear me?
Yep.
Yeah.
When AusNet talk to you, they don't give any details of where on your property, how on your property, why on your property. When you've got a lot of farming activities and a lot of animals, you need to know what paddocks, when, where, how, why, so you can move your stock around. We've seen what happens when they don't give you adequate warning. From as Barb mentioned earlier, the guy that was assaulted in Toolan Vale last year. They don't give you any details, and I think when they want to discuss with you that they want to come onto your property, they should be supplying you with a map, detailed map of your property with everywhere that they want to go and what they want to do, so you can move your stock around appropriately.
That sounds like a really useful suggestion, and certainly resonates for me with a lot of my relatives who are all farmers around what you do around crop rotation and all of that stuff. And thanks, Russell. Appreciate the comments. I think the team saying that item 10 touches on it, but possibly we need to have a look at whether that could be, clauses 10, 11 and the principles around it, but we can look at whether we need to expand that, or if you wanted to put some thoughts about how that might be framed a bit more specifically would be really helpful. I've got a question from Joe. How do we arrange a face-to-face meeting offline with any of you, mainly Sarah and John? Just get in contact with us and we can happy to have a chat. It's nice and simple. We've got a contact email. Just send it through, I think, the contact email address to start out with, and we'll be in touch.
Yes, thanks, Alex. So I think the next one was just from Vicky. Thanks, Sarah, for your response to Barb about what has happened already with poor access actions by AusNet and their poor response to complaints. Can we tell you our stories via the survey? Yes, we would really appreciate you telling your stories via the survey in as much detail as you can share would be fantastic. Thank you. And I can do the next one, John, if you like.
Yeah. Sarah, do you want to pick up that one?
Yeah, sure. So from Joe, comment rather than a question. I truly hope this document is not the beginning of trying to remove a freehold title landowner's right to block access to a property by a company without the company requiring the intervention of a court of law to gain said access and the landowner's right to object. Joe, did you want to talk to that point?
Yeah, all I'm saying is I'm sitting here. I understand section 93. I understand all the grey zones in it and all the rest of it. My concern sitting here now listening to this is that we will be presented with a section, here's the code of conduct and we're coming on.
So I think that probably a simple answer to this question is this document will not subsume anyone's rights in relation to court action. We don't sit above the court in terms of any legal action that anyone might take in relation to something we're definitely on a run below the court as a regulator. And the part that we're doing in terms of developing a code is it sits as a form of tertiary regulation that sits under the primary legislation. So I think that's
yeah. Okay, I suppose the other thing to appreciate here is some of us feel that we have been backed into a corner by this whole process. That is literally your only stand that you can take. That's, yeah. Because we are so against the project, yes, we're going to do the EES, and there's all. If you are truly so against a project coming through your property, your area, your community, I would have thought that the fact that you've got so many people that are standing saying you're not gaining access would indicate how inappropriate the current scope of this is, and the feeling of the community. And I'm just very concerned at the moment that we're about to lose what I think is one of our main avenues to say this needs to be reconsidered.
I think we really hear the strength of feeling there, Joe, and we can hear the distress in the community. I do want to assure you that's not at all the intention of this document. The intention of this document is to make the process fairer around land access, not to take away anyone's rights.
Okay, thank you.
Just Alex, who's next? Oh, is that everyone? Is anyone else like to speak? We can stay as long as people want to. Nate.
You're on mute, Nate, I think.
You mentioned biosecurity before, and going back to the proponents' biosecurity programs. Throughout this whole agricultural region, there's so many different forms of biosecurity and biosecurity programs instigated across the various types of agricultural land, from one end to the other. Now, what has been presented at the present stage is we'll wash our mud flaps and wash our tyres down. Now that doesn't cut the mustard in a lot of situations across biosecurity in agricultural regions, be that the spud country, horticultural country, or even grazing country. So in this legislation, or in this statement as such, are they there to abide by individuals' biosecurity plans that are already in play, which are registered, and a lot of them are registered through the LPA and through other agencies, and yet you're saying that they'll provide us with their biosecurity program? Well, shouldn't they be adhering to the biosecurity programs that are already in play on agricultural land in these other systems?
Look, Nate, thanks very much. If you could maybe send us through some comments, I think that sounds like some very sensible suggestions, and certainly the principles here are all about respecting the issues associated with the land in a broad sense around not causing damage, and that would imply, I would have thought, abiding by the biosecurity plans that the farmer has, or the landowner has, sorry. So certainly on the face of it, it sounds like a very important comment, and really appreciate if you could put any thoughts you have about that on writing to how we might tighten that up, would be great.
No, that's no hassles, but yeah, it's wide ranging and it's not simple. And to say that we're brushing tyres off, and then, like, realistically in some of these horticultural areas, it's full sterilisation of vehicles, but prior to going on to the next property. So because of the soil-borne diseases that can be spread so easily. So the simple brush down method that has been touted as their biosecurity program at the present stage does not suffice for most agricultural enterprises across this region at all.
Thanks, Nate. Really appreciate that input. Darren, you've got your hand up as well.
Yeah, look, I think the most important thing I'm sort of hearing from all this is that, in the case of the Western Vic project, but also for future projects, is the proponent needs to be completely open and transparent with the landowners, and rather than just serving a notice for access, they need to open up meaningful discussions with that landowner, because every property owner or landowner is going to have different requirements for access to their land. And I think it's important, as Nate just said, for AusNet to sit down with these landowners, understand what's relevant and specific to their properties, and actually formulate an access agreement that is specific to their property. I don't think you can apply a broad blanket access agreement to every single landowner. And I think also that the land access requirements need to be very, very specific. As someone mentioned before, when they want to gain access to land, they need to actually explain exactly what they're gaining access for, the period of time they're gaining access, a map of the property indicating what they're going to be doing on the property and where. And it should only be for the specific purpose of that access. So if it's for cultural heritage, they're getting access for 2 weeks and that's it. Because I think one of the issues or concerns amongst the community is that once a landowner signs an access agreement, AusNet have then got the right to access their land for the duration of the project. So for the next 3 years, they can come on whenever and wherever they like. And I don't think that's the case at all, or the intent at all of this access agreement, or a statement of intent. It really should be specific for the purpose of the study they're conducting. And then after that study is complete, their access is denied again. So it's not an ongoing open-ended access arrangement.
That's really useful observations, Darren. Thanks for that. Certainly, the intention is to require them to consult with landowners to understand property-specific needs, and provide details of all of that. And I think your point around putting timeframes around it, so that there's some transparency around why the land's being accessed in the way, and so that everyone has a clear understanding about what it's all about is really interesting. Thanks.
I think one of the things that AusNet have to realise too with this particular project, I mean, these are all good mechanisms to put in place for future projects, and ideally things would run a bit smoother. But for this project that's been impacting landowners now for in excess of 18 months, and we see firsthand the stress and anxiety it's causing in the community, there is no way anyone in the community is going to be open to AusNet being transparent, truthful. They've been nothing but disingenuous and deceitful to date with the information they've communicated with landowners and neighbouring properties. And I think for them, their first step is to try and recover or redeem some form of social licence, because until that happens, any land access that they come walking forward in their hand, people are just going to tear it up and throw it in the bin. And I think that's one of the biggest challenges AusNet are going to have to deal with. While it's fantastic to put mechanisms in place like this, there's a broader, larger issue at hand that AusNet will have to deal with as a corporation.
Yeah, thanks, Darren. That's really useful observation. Do you have any thoughts about how AusNet might be able to, it's an interesting kind of question, how they might be able to demonstrate that? And Nate, I think we've got 2 hands up already. I've got constant hands up here. So are we handing over to Nate, or you want to?
I'm happy to give my thoughts on the matter. I honestly think after being involved with communities in this project and in this process for the last 18 months to almost 2 years now, I think AusNet have lost it. There is no way ever they will recover any form of social licence. The way they've operated as a company has been deplorable. And it's my personal view that they have no business being involved in this project, and I think many in the community share that same sentiment. And it doesn't matter what they do. This statement of expectations certainly is a step in the right direction, but in terms of their social licenses, there's no recovery point from here.
Thanks, Darren. Can AusNet be told to stop their Section 93 access actions until the statement of expectations is finalised? So, very interesting question. I suspect the answer is we can't direct them, but we can certainly take that on notice and have a bit of a think about that comment.
Would be interesting to know, Vicky or other community members, how many people are negotiating with AusNet right now about access.
It's Vicky here. It's hard to know because obviously everybody is just distressed and destroyed by this whole thing, and I'm in full agreement with Darren. They will never ever achieve social license, and it's highly unlikely they will ever get on anybody's land. They've completely destroyed this project. So what you've got, and I'm not saying one way or the other that this statement of expectations is the magic bullet, but what you've got is a community that's feeling pulled in many different directions, are concerned that maybe if they do try to get an agreement that suits them, that other members of the community might have a go at them, or they absolutely, completely and utterly will never, ever, ever allow agreement, and are trying to think of what other options they've got, acknowledging that Section 93 is a legal operation. So I think it's almost, this Section 93 aspect is also something that the umbrella group is still looking at as to whether they even appropriately have Section 93. They're able to use Section 93 under their contract. And I think there's so much swirling around. There's so much problems. There's so little desire by AusNet to enter into any agreement that is suitable. You've got your biosecurity, you've got your Russell asking for maps, where are you going to be? What are you going to be doing? That's been spoken about with them for months and months, if not a year. Every single aspect that's being raised tonight is not new. It's a year or a year and a half old in our concerns. So it's almost like, can we put a huge timeout on all of this, sort it, and then people have a better place that they can then decide what they want to do. And that's not any of us telling anybody what they should decide, but at least some aspect of it is sorted, because at the moment it's just a free-for-all of distress.
Thanks, Vicky. I completely hear the messages we're hearing today about that. A comment from Barb about seasonal operations need priority, and particularly equine land use has been ignored. So I don't know if you wanted to add to that, Barb, in terms of your comments around that.
Oh, hello. Can you hear me?
Yep.
Yes.
So quickly, there's just issues that AusNet, I don't know whether they're just ignorant or just completely oblivious or don't care, but just accessing properties isn't as simple as perhaps they thought it would be. Farming operations, for example, they wanted to come onto us with very short notice, and we're in the process of burning off, spraying chemicals, cultivating. So they did postpone it, but they certainly didn't give us much notice. And then I know with the land use, especially around Melton, there's a lot of equine properties, and it's certainly be highlighted in the landowner that had the, probably in the first 2 or 3 days AusNet started out the process. His horses, apart from him being very distressed, he has race horses. They were very distressed, and I honestly can't see how they can physically unless it's absolutely necessary, get onto properties. There's bound to be incidences, and I have been advised that, so this is a question I'm not, AusNet are telling us they have public liability or they'll have cover insurance, but a retired policeman did say that should there be an incident, particularly if it was under forced access, then their work cover will then come back on the landowner anyway. And so for me, is there an issue if a landowner hasn't given consent and there is an accident, and then work cover want to go under the landowner's public liability cover?
That's a really interesting question. I suspect we'll need to just take that one notice, because I don't know if we've got.
And just for a lot of farms, they're really workplaces, and I know any other business, you can't just rock up and go onto somebody's property without having inductions and all those sorts of things.
Yeah. Certainly, that's something that we've been thinking about in terms of not just health and safety issues, or that kind of accident.
Well, it's really is the landowner still covered if they force access and something unforeseen did happen? That's just perhaps an issue. We won't perhaps know until there's a case or something happens. Anyway, I'll have to leave. But is this recorded?
Yeah, it is.
So I'll be able to send this around to other landowners for them to view, and then encourage them to make some comments.
Absolutely, that would be great.
And the best email was just via the one that I received, was it? And I guess AusNet are probably viewing this as well. And will they be requesting? Will anything be kept confidential that people say, or will AusNet be privy to everything that people write in?
If there's something that you want to keep confidential, if you could let us know. But otherwise, I think it is important that we test what we're hearing with AusNet.
Okay. All right. Thank you.
Thanks, Barb.
So do we have any more questions? I think we might be close to wrapping it up, are we? Or all right, we're all good. Okay, well, it seems like we don't have any more questions, so I just really want to thank everyone for the generosity that you've in terms of your time of coming out this evening, and also the real openness with which you shared the stories and concerns and issues. And we've certainly heard loud and clear the importance of this issue for the community that you all work in. So I do want to encourage you to continue to engage with us, and I really appreciate the offers of coming and talking to us further, and also really encourage you to make submissions, put in your case studies and examples and videos, and any form of submission is really greatly encouraged, either via Engage Victoria or email us through that email contact address. And you can email the team directly via that email address that should be in the chat. There's the Engage Victoria. And as we said, as Sarah said, this is not going to be the only opportunity. So we're really keen to have an ongoing conversation about it, particularly as we get up codes and or statements of expectation. Hearing directly from the community about whether it's making a difference is going to be really important to us. So we're not just going to do a statement of expectations and walk away. We're going to be really following up to see what happens. We want to hear from you about how it's going. And we're going to be talking to AusNet on an ongoing basis about what they're doing to make sure that they deliver. So thank you all for attending, really appreciate it. And we appreciate the time you've taken to be here. We've gone on well over longer than we expected, which is good. And we will be working hard to ensure that this statement of expectations reflects the kinds of issues and concerns that you've raised with us this evening. So thanks everyone, and have a great night.